Swayam Prabha. Digital India. Educated India.
Welcome dear students. Today we discuss dematerialization and rematerialization of security. This is the very important topic of corporate finance, and we not imagine the functioning of stock exchanges without the dematerialization and rematerialization of the securities. I am Dr. Jaswant Saini, Associate Professor, Faculty of Law, present this topic before you. And as usual, we start with the learning outcomes, what we learn from this entire discussion. And this discussion develop our understanding about the meaning and process of dematerialization and rematerialization of securities. Second one, we know about the process of dematerialization of securities. Process word indicate that more than one activity is involved. Where we find out this word process, it means not a single activity. More than one activity when involved, that's categorized as a process. So, to know about the pros and cons of the dematerialization. So, that is the second thing here. We judge what are the benefits, what are the advantages, and what are the disadvantages of this dematerialization of securities. Fourth, to know about the process of rematerialization of securities. Dematerialization basically when we convert our physical type of securities into electronic form of securities. That's concept, that process is known as dematerialization of security. And when we again convert from electronic form of securities into physical form, that process, that activity is known as rematerialization of securities. So, we discuss both type of conceptual study here. One relates to conversion from physical to electronic, and another one conversion of electronic to physical. So, both type of conversions we discuss here, and one is known as dematerialization and another is known as rematerialization. D means lost their metallized process, lost their metallization, and re means regain this metallization. Basic idea behind these words which used by legislature in this act, Depository Act 1996. And fifth one, to know about the pros and cons of the rematerialization of securities. Some drawbacks also attached with this rematerialization of security, and we discuss one by each one here for the benefit of market. Each and every discussion for the purpose of establishment of sound financial system in country. So, the Depository Act introduced in the year of 1996, and from 96 to 98 this act working as obligatory. It means that's on the discretion of the companies, either they follow the rules and regulation of this act or not. It means up to these 2 years this act is not compulsion part. It means this act not applicable as a compelling tool for the companies to convert their securities into electronic form. So, Depository Act 1996 introduced to convert all physical form of shares into electronic form, and this is a drastic change in the corporate law when we introduce this act. So, this act already exists in Western countries, and this act applicable in Western countries 30 years back. In our India, when we adopt this law in India in 1996, that's applicable in Western countries or in European countries 30 years back. This is always tested law. This is tested process who working start in India in 1996. So what's the benefit of introducing this act in our Indian scenario? Basically, some problems attached with the physical form of securities, and this physical form of securities not establish the faith of the investor in the market, and lot of problems attached with the physical form of the securities. And to avoid these all problems, to mitigate these all problems, or to find out the solution of these all problems, we introduce the Depository Act 1996. And Depository Act 1996 till now established that this is foolproof formula to avoid all problems related to the physical form of securities. So, very first benefit of this act, safe and convenient way to hold the securities. There is no any other way is considered as safe way except this act. This act introduced the mechanism or establish the mechanism with the help of SEBI. That mechanism is foolproof mechanism, and that is the answer of all questions. That is the solution of all questions. Once we follow this act, once we adopt this act in our day-to-day functioning of corporate structures, day-to-day functioning of companies, this act held their position at top level. And another benefit is here, through this act, the all problem related to transfer of securities. The major problem attached with the transfer of securities here, we required minimum 40 days time for the transfer of securities. From seller to buyer, when the name transfer, we required the physical form of securities along with transfer deed and stamp duty affixed on this deed, and thus entire material put in envelope, and this envelope when we post, that's posted at the address of share transfer agent. And when they found these all things at proper, they transfer the name, they delete the name of seller and insert the name of buyer. In this entire process, we required 40 days for transfer of name in the securities. But nowadays, when you submit the requisite form in your depository participant end, immediately with the click of mouse, you become the owner of those securities. Those securities come in your account, because these entire dealings in this market related with the already pre-verified trade, immediate transfer of securities possible only due to introducing this act. And third benefit of this act, for whom this act introduced, this is known as elimination of risk associated with physical certificates such as bad delivery, fake securities, delay, thefts, etc. There is a huge list which attach with the physical form of securities. Their physical form of securities you may be imagine with your matriculation certificates. If you have a matriculation certificate in your almirah, in your bag, so what's the position? If you have this certificate in DigiLocker, then what's the position? No need to be care, no need to be worry about the theft, no need to be worry about the spoiling of this document. So each and every problem comes to be an end when we introduce this act. And this act is the more beneficial for investors. Due to introducing this act, faith of the investors established in the market at higher side, and faith of the market is also in good direction, and market respond with their faith. So reduction in transaction cost. Basically in our India, that's the general perception is here, if transaction cost is minimized, we attract the more and more investors. So from introducing this act, when we follow the route of dematerialization and rematerialization, the transaction cost become very minimized, because no need to be print the share certificates, debenture certificates or other bond certificates. Nowadays, these certificates prove your ownership in your account. If your account reflected in credit side these securities, it means you are the owner. If your account not reflected in credit side these securities, it means these securities not against your name in the company's record. So very simple is here, like your bank account. In banks, we deal coin and currency, but in case of depositories, we deal the securities. Securities debit and credit in your demat account. So that's very simplified the entire process of transfer of name, and the all problems attached with the physical form of securities that comes to an end after introducing this act. And another benefit of this act delete or eliminate the problems of odd lot problems. Even one share can be traded. So in the earlier days before 1996, we are governed by the selling of certificate. If certificate have 25 shares, you need to be sold or buy entire certificate. It means 25 shares. But nowadays the lot concept comes to an end. You may be sold even a one share, you may buy even a one share. So that is the problem of lot comes to an end after introducing this act. And another benefit of this act is here, that's automatically credit into demat account of shares arising out of bonus, split, consolidation, merger, etc. Once you enter into the agreement with the company, these shares automatically found in your accounts as per the policy of the company. If you apply through the primary market, if you buy the securities through the primary market, and these securities automatically on the confirmation by company automatically reflected in your credit side in your demat account. So that's a very simple. If there is a bonus share, if you are the benefited with the split of shares, if you are benefited with the consolidation of shares, if you are benefited with the merger or acquisition, with any way, if you are benefited from the company side, that's automatically credit your demat account. That is the full proof formula, that is the answer of all questions. These are the benefits which given by this Depository Act 1996, and in this act the process define how we convert our physical form of securities into electronic form of securities. So in our India, as per this act, two depositories are established. One is known as NDSL. NDSL is the depository established under this act, and second depository is here CDSL. So NDSL established by sponsored, and here various sponsors here, and we discuss here major sponsors of establishment of NDSL, that's known as NSDL, but in brief we say National Depository Service Limited. UTI play very important role in this establishment of depositories. His role reflected in percentage 41.9% equity contributed by UTI, Unit Trust of India. IDBI, Industrial Development Bank of India, established 39.1% equity shares in this NDSL, and NSE, National Stock Exchange, apply their fund 14.3% in this establishment of depository. and State Bank of India apply 4.7% funds. So this is a list of sponsor who apply their funds, who establish these depository services, and these depository services registered under SEBI Act, they obtain the license under section 12 from the SEBI to act as an intermediaries. They are the intermediaries of financial market. So second intermediaries here in this direction, Central Depository Service Limited, and in this establishment of this service, here this earlier established by NSE, so this one established by BSE. So major two exchanges are working in our India, one is NSE, another is BSE. Once NSE established the NDSL, then BSE comes in the picture and they as a promoter establish the CDSL. So Bank of India play their role to establishment of CDSL, Bank of Baroda, SBI, HDFC. So SBI play their role to establishment of this one, and SBI also play their role to establishment of this one. So this is the important thing is here, these institutions established by the premier institution in the market who already act as an intermediaries. So on the initial step taken by these institutions on the direction of central government. So these two depositories working properly in India to smooth functioning of financial market in India, and these depositories play their important role, and only two depositories are working in India. These are NDSL and CDSL. Except these two depositories, no one obtained the license from the SEBI to act as a depository. So we are now coming here, what do you mean by dematerialization? Dematerialization is a process. In my opening words, when we start this discussion, we already define here that dematerialization is the process. It means more than one activity involved in this process by which physical certificate of securities are converted to an equivalent number of securities in electronic form. It means in this process we convert physical form of certificate into electronic form. So this process is designed, introduced by the Depository Act 1996 to convert physical form of securities into electronic form, and this conversion only for the purpose of eliminate the risk attached with the physical form of securities. If we have the physical form of securities, it means lot of problems attached with the same. Maybe the problem of theft, maybe the problem of spoiling the certificate, maybe turn off, or lot of problems attached with the same. Maybe the chance of bad delivery, maybe the chance of mismatch of signature. So lot of problems attached with the physical form of securities. But these all problems comes to be an end when we convert these securities into electronic form, and these securities credit in your account as a beneficial owner. Here four parties are involved in this entire transaction, in this entire process. One is depository, another is depository participant, and third one is here beneficial owner, and fourth one is here this act, and this act is the Depository Act 1996 who provide this facility. And depositories act as an intermediaries, and beneficial owner is the person, the client whose account open here by the depository participant, and depository participant are the agent of the depositories. So there are the four parties, and I may insert fifth one is here, rules and regulation which laid down by SEBI time to time to implement this act for the benefit of investors. As we know that in earlier discussion we held that SEBI governed by this act, SEBI Act 1992, and the goals already settled by the preamble of this act. Preamble of the SEBI Act 1992 defined that SEBI established with the object to protect the interest of investors in security market and development of security market. So, every activity, every act of the SEBI must be in this direction to protect the interest of investors, and here various agencies play their role in this entire process. One of them is depository, another depository participant, another one is beneficial owner. So, all kind of securities such as equity share, preferential shares, debentures, bond, mutual fund units, government securities, sovereign gold bonds and other instruments who cover under the definition of securities, they can be dematerialized. And what is dematerialized? We already discussed here, when we convert from physical to electronic form of securities, that is known as dematerialized. So, Security Contract Regulation Act 1956 define the definition of securities, and all these instruments include in the definition of securities, and these instruments cover under the meaning of securities, and all these securities may be converted into electronic form, and there is no any if and but in conversion of these securities. They relates to any category, they are allowed to be converted into electronic form, and unlisted securities can also be held in demat form. No doubt listed securities are allowed to be converted into electronic form, but unlisted security can also be held in demat form. So, listed and unlisted, that's only differentiation is here. One security if allowed to be tradable in the stock exchange, it means that listed. That is the benefit of listing of securities in stock exchange, that is available for trade. Selling and buying are allowed in the particular security in the stock exchange. Once a security listed in stock exchange, that amounts to green signal of trade in securities. When we are stay with our vehicle on the crossing and green light happened, that is the indication that everything is clear, you go ahead. The same principle is applicable. Once a security listed in stock exchange, that is a green signal to the sellers and buyers that this security is allowed to be tradable in the market. That security deals in market, selling and buying allowed in this security in the market. And once a selling and buying allowed to any security in the market, that establishes the liquidity in the market. The main object of stock exchange is here to maintain the liquidity. When we convert our financial assets into cash, it means that is a liquidity, and this facility provided by stock exchanges. You when sell your shares, debentures in stock exchange, what is the purpose? To obtain the money from the same, and this security is known as financial assets. When you allow to be convert your financial asset into cash, and if they are easily converted into cash, it means liquidity is available in the market. If there is problem in conversion, either the problem of time, either the problem of money, in such cases we presume that liquidity is not available in the market. And liquidity, if once established in the market, that leads to be a good market. That is in the direction of that there is a market in good position, the strength in the market, strength in the particular securities. Lot of securities in the stock exchanges, but once a security buy and selling frequently, it means liquidity in particular security. And if another securities we are failed to find out the buyer, it means there is no any buyer available in the market of such security. It means liquidity is not available against this security. So unlisted and listed securities are both type of securities allowed to be converted into electronic form. They are governed by the rules and regulation of Depository Act 1996. That's the requirement of this act, and that's provide both type of security. And process, what process we follow in the dematerialization? Process of share dematerialization involves 4 parties, and we already discussed these 4 parties. One is here rules regulation, second is here depository, third one is here depository participant, and fourth is here beneficial owner. And fifth you may be include a share issuing company. Any company intending to issue dematerialization share needs to be registered with depository. And how many depositories in India? I already explained before you here NDSL and CDSL. That's your discretion with whom you registered. So once you registered with any depository, it means you opt the dematerialization process. And here share issuing company play very important role. If there is no any company, then whose shares you demat and against whom you claim these securities are demat in my account. So share issuing company play very important role, and nowadays as per legal requirements, every company is bound to be issue securities in demat form. And after 2013, this act insists the private companies also. Prior to this one, this act is applicable on public limited companies and other government companies or other entities except private companies to be issue their securities in electronic form. But nowadays after 2013, the each and every company, either they are known as public limited or private limited, they are bound to be issue their securities in electronic form, in demat form, and for this particular purpose you may be registered with depositories, either that NDSL or CDSL. That's the discretion of the company. They may be applied to whom for registration. So depository, currently there are 2 depositories in India, and one is National Securities Depository Limited, that NSDL, and Central Security Depository Limited, CDSL. So depositories provide companies with a unique 12-digit international security identification number to identify each share and securities. And you know it's very well, each and every share known with their distinctive number when they are in physical form, and when they are in electronic form, they are known with their digital international security identification number. And each share and securities must be possess this number. Without this number, there is no any identity of securities. That is then essential on the part of companies. Before issue these shares, they must ensure that these securities must be identified with their numbers. So concept of ownership is also very important under this act, and owner or beneficiary, generally they are similar terms for the purpose of this act. Under the prevailing rules and regulation, every investor in security market must open a demat account. That is an essential requirement. Investors cannot register for an account on their own directly. Depository participant or brokerage firms register for demat account on behalf of their client, means share owner. So you are supposed to be open a account This account is known as Demat account. Every investor in security market must open a Demat account. So without this Demat account, you are not supposed to be deal in the market. And after this Demat account, you needs to be one another account that's known as trading account. So Demat account play a very important role in this entire scenario, because if you not have a Demat account, then you not participate in the market. And that's the initial step. First you open Demat account before participate in the market. Either you participate in primary market, either you are ready to participate in secondary market, that is irrelevant. Relevant thing is here, first you open your account with the depositories through depository participant, and this account is known as Demat account. For example, if you want to enter into any transaction with the bank, for this particular purpose you need to be first open your account with the bank. Bank note deals with the customers if there is no any account open in the bank. Bank only deals with the customers. Bank never deals with the strangers. That is the first condition on the part of dealings. First you open your account. And nowadays in this digital era, in this present scenario, once you open your account in any branch, you will be considered as the client of the whole bank, not particular branch. You may be dealing in any city of the country if you have the account in particular bank. Branch is immaterial nowadays. Nowadays you are the customer of bank irrespective of branch. The same system is applicable here. Once you open the account with any depository participant, you become the account holder of particular depository, and you may be deal directly through your online mode. So depository participant is the agency here. They are treated as agents who are supposed to be act on the behalf of your direction. So you issue the direction to depository participant, and according to your direction they implement your direction as per rule. So depository participant is registered agent of depositories. They registered for Demat accounts for their clients after processing their registration form and document, and they are supposed to be act on your direction. If you gave the direction, then they act. If you not gave any direction or other than direction, they are not supposed to be act for their own benefit. So depository participant act on your directions. So the steps in dematerialization process, first of all you surrender your physical certificate to the depository participant. So first duty here start when you surrender your certificate, and second duty is here, depository participant intimate to depository regarding request. You made a request, they inform to their higher authority. Higher authority here in this entire process, on the side of depository participant, the depository is the higher authority. So depository participant submits certificate to registrar of issuer company. That company who issue this certificate, they submit to that registrar of companies, and he first ensure that this certificate is original certificate. Genuineness of certificate, if once proved, the other steps start, and that is the fourth step is here, registrar confirm the request. It means request at the end of registrar is available. Registrar of whom? Registrar of issuer company. Confirm that the request is made by genuine account holder, genuine member, then they start the process on this request, and depository update the account and inform the DP, depository participant. Once the registrar confirm the same, then depository update their entries in their record, and they inform the depository participant, and depository participant update the entry in the account as per confirmation made by depository. That is the channel. We follow the route of this channel, then the actual transaction materialize. And this transaction start with whom? This channel, this request, this entire process start with the surrender of certificate by the beneficial owner at the end of depository participant. And registrar update the account and inform the depository regarding completion of process. So, entire process start with the request and with the confirmation and with the necessary entries enter into the record of the depository participant and depository and in the account of the beneficial owner. So, each and every activity here for the benefit of beneficial owner, and this entire process helping hand for maintain the sound financial system in country. Once a sound financial system established, that establish the liquidity in the market, and once a liquidity established, that is a sign of good market. And once we establish the market in international scenario, the reputation of the country established, and that leads to various benefit of the same. Those steps of dematerialization we already discussed in the chart form. That's here: surrender, intimation, submit the certificate, and confirmation of registrar. After dematerializing the certificate, registrar update the accounts. This entire process we know from the chart. So, what is the advantages of depositories? So, before 1996 in our India there was no any depository. So, depositories start working in our India after 1996, and 96 to 98 that's cover under obligatory part. After 98 that's become a compulsory part. What are the advantages to the owners, or you may be say beneficial owner, and you may be say the owners of securities in whose possession these securities available. So, no need to be pay stamp duty. Before 1996 when you apply for transfer of name of the securities, you need to be fill up the transfer deed, and according to the rate of the securities you need to be affix the stamp duty on this transfer deed, and you gave this entire material in envelope, put in envelope and sent to the share transfer agent. So, nowadays no stamp duty is required in this transfer, because nowadays there is a electronic transfer of the securities, and we follow the route of depositories. There only click of mouse is enough for transfer of name in the securities if rest of the conditions are satisfied. If you fulfill the parameters required, legal requirements required, if you fulfill, the other things are immaterial, no need to be paid stamp duty. And second benefit, or you may be say advantage, is immediate transfer increasing the liquidity. So, basic problem is here, sellers and buyers if in the hurry to settle their transaction, this system is very helpful for those. In earlier days we required minimum 14 days for transfer of securities from one hand to another hand, and transfer of money from one account to another account, from one hand to another hand. But nowadays that is the entire process you complete within 3 days. So, immediate transfer increasing the liquidity, and immediate transfer also establish the faith of the investors in the market, and pay in and pay out on the same day. Particularly pay in and pay out is the first step of transfer of name in the securities, and this is materialized in same day. It means, for example, you sell your securities today and someone buy your securities today. it means that day is known as transaction day, and on the same day pay in and pay out materialize. So, that is the major benefit of introducing this act for the benefit of investors. Faster settlement cycle. I already clear before you, in earlier days to settle the selling and buying transaction we required minimum 14 days, and for transfer of name we required 40 days. But nowadays faster settlement cycle is here in 2 or 3 days the entire settlement is possible. So, no need to be wait for a long period in present scenario. So, easy to deal with huge number of securities. If number of securities in lakhs, number of securities in thousand, then no problem. The only click of mouse required here in present scenario. These are the advantages when we follow the Depository Act 1996, and these advantages establish that this act is very beneficial for investors, very beneficial for entire country, and this advantages of dematerialization here in the particular way safe and convenient. This, it means no need to be disclose the vital information before anyone. If information is available to you, you fill this information against your account or in your account, and on your request, that's easily and safe or convenient way for transfer of securities or hold the securities. No one access your account without your permission unless you compromise your keys, your passwords, where no one access your accounts. That's the good step towards digitalization. Nowadays in digitalization, unless and until you compromise your OTPs, your passwords, no one access your account. We only cheated, we are only here become the part of scams or the frauds when we compromise our passwords and necessary information to anyone. So, immediate transfer of securities, that is the task of this Act, Depository Act 1996, and we achieve this task after introducing this one. In earlier days, we start the functioning with T plus 5 days, and now we are in the process of T plus 1 day. The entire transaction materializes in T plus 1 day, and it may be possible in next few years or maybe next few months we convert our entire settlement period in transaction day. So, elimination of risk associated with the physical securities, that's all delete or you may be say eliminate with introducing this demat account process or dematerialization process, or the introducing this act, the concept of bad delivery, fake deliveries, fake securities, delays, thefts and other problems attached with the physical form of securities all comes to be an end when we follow the electronic mode of securities holding. It means demat account or depository participants or depository role start in our financial market transactions. So, transaction cost is minimized. Nowadays, no need to be print the certificates. When there is no printing charges are applicable on the securities, no stamp duties here, no postal charges here, then these all benefits they transfer to the owners, they transfer to the market. So, due to the same, the minimization of costs, when cost cut, that's automatically benefit to the investors, and problem of loads also comes to an end with introducing this electronic form of securities. In earlier days before 1996, that position was different. At that time, if we are interested to sold the shares, we need to be sold the entire certificate. Either certificate carry 25 shares, 50 shares or 100 shares, there is no any chance of fraction of shares. There is no any chance of split of shares. We need to be sold the entire certificate. So, nomination facility is also applicable in present scenario because you are running account. In accounts, nomination facility is available. In earlier days, that is very difficult to appoint the nominee in such dealings of financial transactions. So, change in address recorded with DP get registered with all companies in which investors hold securities electronically, eliminating the need to correspond with each of them separately. If you have the security of 20 companies, in all 20 companies your address which reflected in beneficiary owner account, Demat account, being a beneficial owner, that is reflected in all records of all companies. No need to be mentioned the separate your address and other details. So, automatic credit into Demat account of shares arising out of bonus, out of split or consolidation or merger. Due to any reasons, if any securities credit in your account, that is automatically credit in your account. No need to be made a separate request for the same. No need to be deposit in physical form, because nowadays there is no security available in physical forms. But we discuss later on, that is the process of re-materialization also available in this act, and on the request of beneficial owner, company is bound to print this certificate. If some owners, some investors interested to take the physical delivery of the certificates, they are allowed to be converted in the physical form, that is also allowed on the name of re-materialization of securities. So, holding investment in equity and debt instrument in a single account, that is possible due to this Demat account, due to this deposits. No need to be open the separate account for securities or the debt. All securities you may be kept in single account. So, compulsory Demat for pending transfer deeds. Transfer of listed securities held in physical form is not allowed with effect from April 1st, 2019. So, that is the trigger date which restricts to hold the physical form of securities. It means listed of securities not allowed. Every stock exchange only listed those securities which are issued by the company in Demat form. Transfer of securities belonging to unlisted companies is also not allowed. Nowadays, unlisted company also issue the securities in Demat form. That is listed or unlisted for the purpose of stock exchange, not for the purpose of Depository Act 1996. The purpose is different here. So, resubmission of transfer deeds which were submitted prior to this but were rejected or returned is allowed till March 31st, 2021. Due to any reasons, if your request not materialize and that is a return your request, that is allowed up to 31st March 2021, and that is also again materialized by this act. So, shares pending for transfer with listed companies, its RTA shall be issued only in Demat form. So, nowadays our central government compel to the all companies, they issue the securities or transfer the securities only in electronic form. So, physical form of securities decline at every level by the issuer company, by the SEBI, by the depositories. So, we are in this direction to be deals in the securities in electronic form. Upon relodgement of transfer deed, RTA shall retain the physical shares and inform the transferee about the execution of transfer through letter of confirmation. So, here letter of confirmation is also play very important role if there is an execution of transfer through this letter. Otherwise, we transfer the ownership with the ownership proof, but letter of confirmation is also sufficient to materialize these things. Transferee shall submit a demat request to its DP on the basis of letter of confirmation within 90 days, and demat request shall be processed by DP on the basis of letter of confirmation, and request shall be processed by RTA, it means transfer agent, and upon confirmation share shall be credited in transferee's demat account. In case transferee does not submit demat request within 90 days, share shall be kept in suspense escrow demat account. It means escrow account or specific account which open for specific purpose. So, this account is a suspense account. Your securities may be kept in this account if you not fulfill the rest of the requirements. And generally we know what's the reasons of rejections. These are the some common reasons here for rejection of your request. If you mention incorrect name, that is one of the reason, mismatch the details, and transmission request improper, signature mismatch, mismatch between share quantity received and DRF quantity, court injunction, if court pass the injunction order, that's also in such cases that's become a ground of rejection. Certificates sent are reported stolen. Already they are the fourth certificate and they are stolen certificate, and already FIR laws against this certificate, that's also become the ground of rejection. Duplicate certificate already issued by the company against the particular owners and they claim the different certificates. So, forfeited securities surrender for dematerialization, and certificates are forged certificates. These are the basic reasons for rejection of requests. So, we consider here on this ground your request rejected. They are the common reasons. And allotment payment receipt not attached, that is also one of the reason. Certificates are stolen or defunct certificate, forfeited securities and forged. So, what to do in case of rejection of demat request? The point is here what we do now when our request is rejected. So, your DP will inform you about the rejection of demat request. You can also see the transaction status in your statement of transactions and understand the reason for rejection from objection memo sent by issuer / RTA, transfer agent. So, rectify the errors, remove the deficiency in the documentation, submit demat request once again through your DP. Once your request deny, you are supposed to be submit again with correction, with required documents. So, now we are coming here the part of rematerialization. Rematerialization means investor can opt to rematerialize their shares even after dematerialization. So, rematerialization is against that is a process of converting the dematerialization shares back to physical form of shares. If you are interested to take physical form of shares, you fill up this form and submit to your DP, and DP made this request to the issuer company and informed to the depositories. So, that is the process also. Some investors opt to rematerialize their shares in order to avoid maintenance charges on the demat account. Once you open the demat account, you need to be paid some necessary charges on each and every year. That is the maintenance charges. And some persons who are not interested to give these charges, they may be kept their security in physical form. Post rematerialization, the investors can conduct transaction physical only. So, nowadays your securities not deal in physical form. So, ultimately when you deals in securities and when you sold your securities, you need to be again convert in demat form. The process of dematerialization is very simple. Investor or interested person need to submit the remat request in the form of RRF to the depository participant. The depository participant approaches the depository with this form. Then it forwards the request to the registrar. The forms are then handed to the registrar for verification, and the registrar prints new physical certificate and forward them to the investor who want to rematerialize its share or securities. Once the registrar confirms the remat request to the depository participant, the investor or the person receives the new certificate in the account. The process of rematerialization is completed within 30 days. So, this act imposed the restriction, the limit of the time period within 30 days you complete the entire process of rematerialization. So, relevant legal provisions here highlighted for rematerialization. Bylaws 9.4 of NSDL define that rematerialization, this talks about the legal method of transferring securities. Business Rule 11.2 NSDL, rematerialization of securities, talks about transferring of these securities to other important legal guidelines. Bylaws 13.5 of CDSL deals with the process of rematerialization. So, advantages of rematerializations are not good or not maximized. The record keeping, some investors prefer physical certificates for ease of record keeping and tangible proof of ownership. Electronic risk, some investors may perceive physical certificates to avoid certain risks attached with hacking of accounts, cyber threats or unauthorized access. And maintenance cost, they are some reasons for whom some apply for rematerialization. And some disadvantages of rematerialization: inconvenience, higher risk of loss or damage, regulatory compliance, limited liquidity. So, these are the disadvantages attached with the rematerialization of securities. Now, we are in the last part of this entire discussion, summarized part. Dematerialization is the process of conversion of physical form of securities into electronic form, and rematerialization is also the process of conversion of the dematerialization form to physical form. So, there's the key parties are here 4 in this dematerialization process. One is issuer company, second is depository, third one depository participant, and fourth one beneficial owner. And dematerialization ensures the safekeeping of securities in electronic form, eliminating the associated with the physical form of securities such as loss, theft or damage. Thank you.
When Copernicus said the earth revolves round the sun, it was considered blasphemy. When Galileo said the earth was round, we thought he was mad. When Darwin said that monkeys are the ancestors of man, we thought he had lost it. When the ecologists said this was the end of the world and the human race, we didn't believe them.